Good morning.
Morning, Judge.
How's everyone doing?
Good morning. Thank you.
Well, good morning. So we're here on a series of Durrani cases, and what I understand is we'll be doing the consolidated cases first. Is that right?
Yes.
Okay, so we're going to be hearing first the cases of Jansen, Underwood, Legendary, Applegate, and Collins versus Durrani et al.
Yes.
Very good. So if each party can please identify themselves for the record and their readiness to proceed.
This is Jim Moss, the appellant's Applegate.
And just so you know, counsel, you're just a little choppy.
Oh, I apologize. We're on top of Carew Tower. I don't know if that.
Yeah, it's just that it'll be, your argument is going to come across a bit choppy.
Okay, good. We were speaking with Julie Nestor 5 minutes ago, and we weren't. I guess we weren't aware of that.
Okay, and maybe that signal was clearer then. Good morning.
Good morning. Jennifer Mitchell on behalf of the Christ Hospital.
Okay, thank you. All right, counsel, whenever you're ready, and would you like to reserve some time?
Yes, I'd like to reserve 3 minutes for rebuttal.
All right, whenever you're ready.
Thank you. There's many cases consolidated in this hearing before the court, and we submit on the briefs. I'd like to focus on the Evans case, which was submitted as recent authority, Supreme Court case Evans versus Akron General from December 2020, and its use of Browning, because we understand the first district's position, but we disagree that Browning's been overruled. Specifically, Evans quotes Browning and uses and states negligent credentialing claims arise out of the hospital's failure to satisfy its independent duty to grant staff privilege. If it arises from the hospital's failure, its independent duty, then it does not arise out of diagnosis, care, or treatment. And every medical claim listed in 2305.113E arises out of medical diagnosis, care, or treatment, including the claims that Christ Hospital, or the clause that Christ Hospital relies upon, the hiring, training, supervision, retention, termination of caregivers, which they claim includes, but it doesn't. But even before you get to that clause, you read subsection E3CII. It states it arises out of medical diagnosis and results of the hiring, training, etc. Just about 90 days ago, the Ohio Supreme Court says credentialing claims arise out of the hospital's failure to satisfy its independent duty on credentialing.
Well, but they weren't addressing the medical claims definition, were they?
That wasn't the issue before the court, but that's the third time that the Ohio Supreme Court has quoted Browning and applied the foundational rulings out of Browning. So there isn't any way you can say that it's been overruled.
But the determination that it's a direct claim against a hospital, how does that negate that it's a medical claim?
Because it arises out of the hospital's failure on credentialing and not out of diagnosis, care, or treatment. And in Browning, which has been, and the quote from Browning is, hospitals don't practice medicine, only physicians do. It doesn't arise out of medical diagnosis, care, or treatment. And all medical claims have to do that. And if it arises out of something else, then it doesn't arise out of diagnosis, care, or treatment. And you just can't consider it a medical claim. They even use the same term, arise. Credentialing claims arise out of the hospital's failure on the credentialing.
But we've walked through the history of the medical claim definition, how it's changed over the years, and how it's been broadened. And I guess does Evans impact that analysis in any way?
I'm sorry, Judge, you're breaking up. That, please, I apologize.
Well, in our prior decisions, we've walked through the definition of medical claim, how that's changed by the General Assembly over the years, and how it's been broadened. And so my question is, does Evans impact any of that analysis?
Well, yes, it does. It clarifies that the credentialing claims don't arise out of diagnosis, care, or treatment, which is that's the ruling in Browning. That's the basis of the holding in Browning. They arise out of the hospital's failure to satisfy its independent duty. And actually, in the original case, Young versus Durrani, Browning was never even mentioned or addressed. That was from 2016. And in addressing another case, I found a case called Rush versus UC Health Physicians, which came out 3 months before Young. The first district applied the concepts for Browning in arriving at its holding. 3 months later, when they addressed the exact same issue, Browning wasn't even mentioned, not in the opinion.
So what do we do with the language in 2305.113E3C little II that talks about results from hiring, training, and so on? So you're focusing on the C part that says arises out of, and then we have the results from.
Right, and first of all, you don't get there because it does not arise out of care treatment, but the exact clause you're talking about, hiring, training, supervision, retention, or termination, doesn't include credentialing, and credentialing is its own detailed legal process, or medical legal process that's described fully in 2305.251, and it actually lays out the elements for a negligent credentialing claim. It talks about presumption of non-negligence by an accredited hospital that can be overcome in a negligent credentialing claim by showing a pattern of incompetence or inappropriate behavior, or knowledge that the provider would commit fraud. That's a completely different issue than establishing a medical.
So is credentialing intertwined with hiring, supervision?
No.
It's not intertwined with supervision.
No, because Durrani at Christ Hospital was an independent contractor. He was in charge of the medicine for that. Once he's credentialed, he has that independent decision making. And then every 2 years, he's credentialed for reappointment. He's not retained, he's credentialed for reappointment. That's the term that doctors use. In Schmidt, the Ohio Supreme Court quoted Browning saying that credentialing claims and medical claims have different triggering events from the malpractice claim, which absolutely means they're totally different claims. If they have different, how can you apply the statute of repose to a credentialing claim when it's based on different acts? The malpractice claim is a violation of the standard of care, but according to 2305.251, the peer review statute, but it also has credentialing. It requires a pattern or inappropriate behavior, or the hospital's knowledge the provider would commit. Under what Christ Hospital is arguing, a practitioner would have to sue every time there's a medical claim. Would have to sue, or she would have to sue for credentialing also, even without the evidence. Just to be able to sue in time if you're going to apply the same medical claim limitations to credentialing in violation of Browning. The Supreme Court's discussion of Browning and Schelling from 2009 also illustrates bifurcated claim. Try the claim first, then the credentialing. I think Christ Hospital would disagree with that. When we tried our Durrani case, Westchester on bifurcated, running the medical claim first, then bringing in the credentialing issues once liabilities. We never had a trial because Westchester Hospital settled after 2 jury verdicts against Durrani. We did have one against Children's Hospital, and then after that, Children's Hospital settled.
Are there any questions from the panel? Okay. Thank you, Attorney Moss. So I have your 3 minutes reserved.
Okay, thank you.
Thank you. Good morning, Attorney Mitchell.
Morning. Thank you. And I guess for purposes of brevity, I will address, as I did, I believe, in the argument just recently with at least 2 of your honors, the Evans case, and lend the argument to that as Mr. Moss did, because I believe that they're misinterpreting Evans and what the propositions that they're arguing stand for and what they don't. They're keying in on some language in paragraph 10 of that Evans case, which is really addressing a different issue entirely. And the court is citing cases for the proposition that the employee's tortious or criminal conduct doesn't have to be proven in a separate proceeding, other than in order to bring a credentialing claim against the hospital. And so throughout that decision, in that case, the hospital was arguing that the employee, and again here, Mr. Moss is correct, Dr. Durrani was not Christ Hospital's employee and never was at any time. So that's another distinction that I believe is important with respect to this case's applicability to any case involving the Christ Hospital. But the issue there was that the hospital was arguing throughout and had prevailed at one point on the argument that there had to be an adjudication as to the civil liability or criminal culpability of the employee who had allegedly committed the wrong in order for a claim for negligent credentialing to proceed. And the court was addressing that issue in saying that the claim is independent, so to speak, from the claim against the employee. That's all that was saying, and that's all that was citing to Browning for, but they're taking that holding completely out of context and attempting to conflate it to a statute of repose case when the Evans case was a limitations case. And it wasn't a medical claim in that case. And certainly here, where you have a statute of repose that addresses medical claims and includes the claims of negligent credentialing, supervision, and retention, as was alleged here by the plaintiffs in these underlying cases, and again on appeal by those same plaintiffs. It is a different situation than what the court was presented with in Evans, and it's not on point and doesn't supplant this court's most recent rulings in Jonas and McNeil and the other cases where it has laid out very clearly the analysis with respect to the credentialing claims being medical claims under 2305.113C. So we would just argue to this court that the Evans case doesn't have any impact on.
In those cases that you just referenced, Jonas and McNeil, I mean, the other side sought Supreme Court review on that issue, didn't they? And the court did not grant it on the negligent credentialing issue.
It did, yes. Thus far, in any case that has been taken to the Supreme Court and ruled upon by the Supreme Court, the court has declined to take jurisdiction. And your rulings are intact in all of those that have proceeded to the Supreme Court and have been ruled upon. Some are still up there. But to this point, the Supreme Court has declined to take jurisdiction in any case, leaving these decisions intact.
How would you address Attorney Moss's argument that credentialing is not intertwined with hiring, training, supervision, retention, nor is it with termination?
I would disagree with his perspective that the credentialing claims are not included within the definition of medical claim. And I believe that would be consistent also with what the Ohio Supreme Court has explained in its decisions, where it has held that in order to prove that negligent credentialing claim, and these are decisions that went into effect that guided the language that we currently find in RC 2305.113C. But the Supreme Court twice, I believe, in Schelling and even in Browning years prior, explained that credentialing claims, in order to prove those, to prove a negligent credentialing claim, a plaintiff injured by a negligence of a doctor must show that but for the lack of care in the selection or retention of the doctor would not have been granted privileges and the plaintiff would not have been injured, and it goes on. But I think that that language is very clear. Then what you see following those rulings is the current version of the statute, which addresses or attempts to address that logic and says, and the statute was amended to specifically include claims that result from the hiring, training, supervision, retention, termination. The court is attempting, or the legislature was attempting to broaden and encompass the negligent credentialing claims as well with that.
I think, and I think the heart of Attorney Moss's argument this morning is that that Dr. Tehrani was not an employee and he was an independent person. And as such, that these terms, hiring, training, supervision, retention, termination, apply to employees, but not to a person who's not an employee of the hospital.
I did hear that. It was a little bit garbled at points, but because of the transmission, but I would disagree. I mean, otherwise, then perhaps the claims shouldn't have been brought at all, but hospitals do credential physicians. They decide whether or not to retain them on their medical staff, and they make those decisions on a regular basis. So I do believe that it would apply to both. And if you look at the rulings previously, the language that I just cited to you, it talks about it being a staff doctor. So a staff doctor doesn't necessarily have to be one that's employed. It can also be one that's just on the medical staff. Almost every hospital probably has doctors on its medical staff that are not employed.
Was there anything further, Attorney Mitchell?
No, thank you, Your Honor. We would just say that the court should uphold the trial court's rulings on all of these cases and not find any error. Thank you.
All right. So unless there's any other questions from the panel? No, okay. Attorney Moss, you had asked for 3 minutes. You actually didn't use your initial 13 minutes, so you have 6 minutes in rebuttal.
Okay, thank you. The General Assembly used the term credentialing in the same chapter, 2305, 2305.251, credentialing, and laid out even the elements of the claim. Yet they chose not to include that in the clause, hiring, retention, termination clause relied upon by the hospital. They did that for a reason, because that would have conflicted with the Ohio Supreme Court. And in addition, they left in the phrase from the prior statute, it must arise at a diagnosis, care, or treatment. All they had to do is put credentialing in there. They don't have selection in there. These are clearly employment terms. And it relates mainly to staff employees, nurses, and that kind of thing. Because you have to name a physician. In Ohio, you have to name individual physician, whether he's an employee or a staff physician with just privilege, an independent contract. So the fact that credentialing is not in 0.113E, yet is in 0.251, shows it was intentionally left out. And credentialing has been in prior versions of the statute, but that was with the stated intent to overrule Browning. But that was found unconstitutional in the Seward case. And then just last December, the Supreme Court once again, cites Browning, and it wasn't a credentialing case, I know that, or we'd have the answer. But I believe we did get the answer because it says credentialing claims arise not from diagnosis, care, or treatment, but from the hospital failure to properly comply with its credentials. And that's not care, so it can't be a medical claim. So we'd ask the court to reconsider the Young decision, which never discussed Browning, and all the other cases that followed, and find that negligent credentialing is not a medical claim, which would result in the denial of their money because they rely on the medical claim statute.
Thank you for both of your arguments this morning. Unless there's any other questions, we will take the matter into submission and issue a timely decision. And now we're going to move to the case of Bachman versus Durrani et al.
Okay, we're gonna move our camera to Bob Winter. So
Okay,
the camera will be shuffling a little bit.
okay. So Attorney Winter, you'll be arguing this morning on the
I'll do my
Bachman
best,
case?
Judge. Yes, ma'am.
Okay. And just be aware, it is choppy where you're at. And so your argument is not coming across smoothly.
Can you hear me now? Is it choppy?
I mean, it's just choppy, you know what I mean? So,
We have such wonderful technology these days. Yeah.
yeah. Well, what I've learned recently is when you're in the top floor, there's a lot of equipment, and a lot of it is networking equipment, and so it does tend to interfere with the network on the upper floors of buildings. At least that's what a technology person told me recently.
Okay.
All right.
Qualification, Judge.
So if each party can please identify themselves for the record and their readiness to proceed.
Yes. Good morning, Judge. My name is Robert A. Winter Jr. Present the appellant's case and ready to proceed with argument.
Good morning.
Jennifer Mitchell on behalf of the appellee, the Christ Hospital.
Good morning. Attorney Winter, did you want to reserve time?
3 minutes sounds good, Your Honor.
All right, whenever you're ready.
Thank you. Thank you. Good morning. This case started off, let me back down. The last time we were before this court on a Bachman case, Judge Meyer asked me why consolidation. And I think that's a fair question. The case originally started with a series of individual cases involving my clients against Durrani and Christ Hospital. We were in the process of negotiating a settlement with Children's Hospital, and it turns out that the surgeries were performed by Dr. Durrani at Christ Hospital while he was an employee of Children's, and thus the need to refile claims against Children's. During the process of negotiating with Children's, we were exchanging lists of cases that they were involved in, and we saw some cases the children said were ours that we didn't know about. Along the way, you'll see in Exhibit 1, which is filed under seal. I don't mean to breach any seals, but the Honorable David Brittingham state unequivocally that the settlement process and the litigation process was, quote, time sensitive, and we took that seriously. And the reason for that is that there are statute of repose issues involving Dr. Durrani and Children's, and argued Christ Hospital. So there are several surgeries on Children's Hospital's list that were actually done at Christ while he was an employee of Children's. And again, most, if not all, of the the Christ Hospital cases have already been filed. The solution to the timeliness and the rush was to file a group complaint against Christ Hospital, Children's, and Durrani. This is similar that was done at the Dieters firm with a case whose lead plaintiff was called Nicole Baker, which was case number A604542. It was a group filing, and it was an attempt to beat deadlines as they went on the timeline.
Oh, Mr. Winter, this is just a case against Christ at this point, right? This appeal.
As it is now, Your Honor, I'm just trying to explain the history of how we got here.
Okay, well, so I guess I was under the impression that you thought that the Bachman case was different than the other cases slated for today. So I'm just trying to understand what your view is on that.
All right, we're here on the entry of sanctions for frivolous litigation in Rule 11 entered by Judge Schweikert against Peters Law Firm and the late Fred Johnson and Ben Moran.
I'm sorry, you're here on a sanctions decision?
Yes, sir. Yes, sir.
Okay, I apologize. I have just the brief that I have that I read was just was very similar to the other 5 briefs of the cases today. That was challenging negligent credentialing, all the issues that we just discussed, fraud and equitable estoppel. I don't have a brief that is challenging the sanctions determination.
There is another Bachman case coming down the timeline where we do have those issues very similar to this, but this is I had the C-19-514.
19 what? I apologize.
19-514.
That's the sanctions case?
That's
Yes.
not the one that we have on the docket today.
No.
Okay. Well, then I think we have the same issues in the Bachman case, having all those argued by Ms. Mitchell and Mr. Moss.
Right. So the case that we have on our docket is 20-0110, and it does have the same issues for the other cases that were scheduled today, which is why that was my source of my confusion as to the distinction between the cases.
Judges, you're right. And the principles on the marriage of Bachman are the same as Applewood, Worley, all those other the attorneys just got.
Okay.
So, but we still have the sanction matter outstanding, and I guess we reserve that for another day.
Okay, thank you. Would you like to argue any response, Attorney Mitchell?
I would agree that the issues in the present case being heard before the court are the same as those just argued. So no, I don't have anything further at this time. Thank you.
Okay, thank you. So unless there's any questions, then we will also take this matter under submission and issue a timely decision. And we wish you both a wonderful